So many people are under the impression, and it's a false impression, that domestic law, government law, statutory law that is created by the government is the all-ruling mechanism, is the most powerful law, and that it requires our surrender, our submission, our obedience to the domestic law. However, that is not the case. Domestic law is not the hierarchy in law. When you're talking about law and dealing with law, your domestic government's laws that they create through the legislator is not the ruling force. The governments, like Canada, will pretend that their laws are the ultimate say. They will pretend that their laws have the ultimate authority and that we must submit. Not only do the governments create domestic law, statutory law, but then they go ahead and they create a whole system of enforcement to try and enforce these laws against individuals, to try and force men and women to submit and to follow the laws that they create. I want you to recognize and understand tonight or today, whenever time it is that you're watching this video, that domestic laws are subservient to the international order. Domestic law must follow the operations of law, the principles of justice, and the rule of law that is brought forth under the international order. And if the domestic law fails to do so, then it's of no force or effect. No power behind those laws. If they breach the international order, then their laws are of no force or effect, period. And this invalidating power against domestic law is clearly brought forth and enumerated in the Constitution Act of Canada 1982, Article 52, where it states that the Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is of no force or effect. The ICCPR, Article 2, Subsection 2, were not already provided for by existing legislative or other measures. Each state party to the present covenant undertakes to take the necessary steps. That's a legal obligation, a legal promise, in accordance with its constitutional process and with the provisions of the present covenant, to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So what's the Constitution Act of 1982? What is it there for? Well, it's there to give effect to the rights recognized in the present covenant. That's what it says. That's what the international order declares. It says, if you don't have these rights operating in your territory, then State Party Canada, you are under the obligation to create a constitutional process, to adopt the laws, and to bring forth the rights that are recognized in the covenant into domestic law. So that's exactly what the Constitution Act of 1982 is doing. Some will say, and some will take the position, that the Constitution is not for them. Well, that's okay then. You're being a fool, because the Constitution is directly for you. It's there to protect your inalienable rights. It's there to protect your natural, absolute human rights. And without it, and without standing under it, you have no protection in the law. Meads versus Meads, a claim that the relationship between an individual and the state, meaning the country, like Canada, is always one of contract, is clearly incorrect. So those who teach you and tell you, oh, everything's a contract with the government, and if you just deny the contract and don't accept the contract and set up your own contract and set up a tacit agreement, then you'll be free from the obligations of statutory law. Well, everything's a contract. It's an offer and acceptance. Well, the courts have said to that argument, the courts have declared that this is clearly incorrect. All right. So if you still want to take that argument and you still want to hold on to that belief, well, when you go before a court and you start bringing that argument, they're going to tell you you are clearly incorrect. But the state has the right to engage in unilateral action. They have the right to apply their laws against you, their statutory laws against you, but subject to the charter. Oh, but the charter is no good for me. Oh, and the charter is only for the government. The charter is not for me. It's for a corporate body. Well, it's not what the court says. The court said that the government will apply their laws against you only subject to the charter. And what does the charter bring forth? Well, for those who are unaware and for those who have not woken up yet, the charter brings forth inalienable rights. It brings forth your natural rights, your absolute rights. That's why the courts declare this. The courts, if we read this sentence and we rewrite it, what it's telling us, it's saying that the government of Canada will apply their laws against you only subject to your inalienable rights, only subject to your natural rights, your absolute rights, better known as peremptory norms, peremptory obligations, non-derogable rights. But that's what the court is saying here. But if you don't understand what the charter represents to you, then you don't see what they're saying. But when you wake up and you learn the principles of justice and the rule of law, then when you come to a declaration like this from a judge, you understand what they're saying. They're saying they're going to apply their statutory laws against you. Oh yeah, but that's not right. I'm a man. I'm a woman. I have a right to be free. I have inalienable rights. I have natural rights. Oh, they're common law rights. Oh, but they're in contract. No, they're telling you, we're going to apply these rights subject to the charter. Well, why subject to the charter? Well, because the charter is bringing forth your inalienable rights. And it is protecting your natural rights. And if you can understand that, and if you can bring it forth before them, then guess what? They can no longer unilaterally apply their laws against you. Because now you're protected. Because now you're standing under international order that recognizes your inalienable rights. Oh no, eternally aware, you don't understand. They're my common law rights. I don't need the charter. I just got to call on common law rights. That's all. Just tell the government, hey, it's a contract and these are common law rights and I have common law rights. And then I'm free. I'm free to fly like a bird. It's not what the court says. Supreme Court has made it clear in cases MA versus Ryan that the common law must develop in accordance with what? What does it say here? With charter values. Well, why is the court declaring that common law must develop in accordance with charter values? The charter is only for a corporate body. Charter doesn't apply to me. It only applies to the government. All the hundred excuses that the false teachers use out there. And the court is declaring that the common law must develop in accordance with charter values. Why? Because the charter is protecting common law rights, which are inalienable rights, which are natural rights, which are absolute rights. That's why the court is declaring that common law now in 2025 must develop. It's an obligation. Must develop in accordance with the charter values. A trespass in common law, meaning a trespass of your inalienable rights. A trespass of your absolute rights equals an infringement or denial of a fundamental right or freedom that is listed in the Constitution Act or the covenants themselves. But most of these false teachers, right, they don't even know how to point to the charter to bring forth their fundamental right, to express their inalienable right. Therefore, they can't defend themselves. So they make up their own rule of law and they make up their own system and they tell you this is the way. The ICCPR, Article 2. Each state party to the present covenant undertakes to respect and to ensure to all individuals within its territory and subject to its jurisdiction the rights recognized in the present covenant. All right, so we're seeing here, right, that it's the ICCPR that is controlling domestic law. And the ICCPR is telling Canada's domestic law, you have an obligation. And your obligation, domestic law in Canada, is to make sure that you undertake and respect and ensure to all the individuals on your territory the rights that are recognized in this present covenant. You have a legal obligation to make sure that you give an expression of law that allows all individuals to stand upon the rights that are recognized in the covenant. That's a command from the international order flowing down into domestic law. So who's in control? Who's on top? Is it Canada or is it the international order? Well, it's very clear to see, right, that it's the international order that is commanding domestic law. The ICCPR preamble, considering that in accordance with the principles proclaimed in the Charter of the United Nations, well, we're going to learn some principles that have been commanded down upon the state party. Recognition of the inherent dignity and of the equal and inalienable rights. Well, there it is, right? Very clear to see that they're teaching us and they're telling us that the covenant is bringing forth inalienable rights, your common law rights, your natural rights, rights that belong to men and women that were not given to us by the government, but are being respected in the covenant, are being recognized in the covenant. And let me tell you, in case you don't understand fully, they're not recognized anywhere else. You can make up your own principles of justice. You can make up your own story in law. You can make up your own things in the law and claim that's the way to go. But they are not recognized anywhere else. The legal obligation upon Canada comes from the international order. End of story. And anyone else who tells you otherwise is a false teacher and is showing you false operations of law that is going to get you in trouble. Considering the obligation of states under the Charter of the United Nations to promote universal respect for and observance of human rights. So they have to promote and respect and observe our human rights. And our human rights include our inalienable rights. They include our common law rights. They include our absolute natural rights that were not given to us by the government, but must be respected because the law demands so. The ICCPR, Article 2, Subsection 2, we're not already providing for, by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps, legal obligation, in accordance with its constitutional process. Oh, there's the charter. And with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. Oh, so they got to give effect to the rights recognized. And we just saw that some of the rights that are recognized in the covenant are what? Well, they are our inalienable rights. They are our common law rights, our natural rights, our absolute rights. And here the covenant is bringing forth the legal obligation upon Canada, upon the legislators, upon the executive powers, that you have the legal duty and responsibility to bring forth laws through the constitutional process to give effect to inalienable rights. Article 5 of the ICCPR. It's a very interesting article of law. It says nothing in the present covenant may be interpreted as implying for any state, group, or person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized therein, or at their limitation to a greater extent than is provided for in the present covenant. So another legal obligation upon Canada, right? Says you cannot take any action or perform any activity that destroys the rights that are recognized in the international order, that are recognized in the international covenant. Okay, but we have inalienable rights and we have common law rights. And many people are aware of this. And many people are claiming, hey, look what the government's doing. They're taking away my rights. I have natural rights. I have inalienable rights. What should I do? Well, write up a contract and tell them you don't agree to the contract. Whoa, create a trust, a private trust. And then you'll have your common law rights. You have your inalienable rights. Many people get stuck here. This is where they're stuck with. Under Article 5, they're realizing that Canada has performed activity and taken actions that were aimed at the destruction of their common law rights, of their natural rights. And they realize it and they understand it, but they don't know where to go from there. They don't know how to communicate with the government. They don't know how to express their rights. Like I said, they fall under, a contract or a private trust. But here the law is teaching us that if you understand and you see that your natural rights have been limited, then, according to the international order, Canada is going against their legal obligation. There's no operation of law. There's no principle of justice. There's no rule of law that Canada can call on that allows them to limit and abridge your inalienable rights, your common law rights, your absolute rights, your natural rights. This is a peremptory obligation under law. Your rights automatically command respect from the government. Without question, non-negotiable. They are under legal obligation to respect, to ensure, and to recognize your common law rights, but they are failing to do so. They are creating statutory law, domestic law, that is going against their legal obligation to the international order, and they're banking on the fact that you won't understand what they're doing. And they're using their statutory law to pretend it's the highest law out there, that you have to follow it, that it commands your respect. Well, all along, they're breaching your natural rights to put this operation of law against you. But because you know it's not, that they're breaching your absolute rights. You don't know how to defend yourself. They're breaching their obligation to inalienable rights by forcing you into statutory recognition, by forcing you to follow domestic laws that bind up and limit your common law rights, your inalienable rights. And there is no principle of justice for them to be doing so. They are hiding behind our ignorance. The Vienna Convention on the Law of Treaties, Article 27, Eternal Law and Observance of Treaties. A party, that includes Canada, may not invoke the provisions of its internal law, its statutory law, its domestic law, as justification for its failure to perform a treaty. So they cannot point to domestic law and say you owe an obligation to this domestic law, if in that obligation that they're pointing to, they're denying you your inalienable rights. They're denying you your absolute rights. They're denying you recognition of your natural rights. And they're pointing to their statutory law to do so. Then they are partaking of illegal actions. They are breaching the international order. And according to Article 52 of the Constitution of 1982, their law is of no force or effect. That's the truth. They may not point to their internal laws, to their statutory laws, as a justification to failure to perform their treaty duty, their treaty obligation. Well, the statutory law commands it. Yeah, well, hang on a second. That statutory law, right, that you're standing on, right, that's breaching my inalienable right. That's breaching my natural right that is recognized in the international law. Article 16 says, I have the right to remain in my natural capacity with no impositions and no duties placed upon me, no obligations to statutory law placed upon me. And yet you're trying to do this. You're trying to force an obligation upon me. And by trying to force that obligation upon me, you are breaching your legal obligation. You are breaching your legal duty to the peremptory norm of international law. And those peremptory norms, they respect my common law rights. They respect my inalienable rights. They respect my natural rights. That's why they're there. That's why they are in operation. And that's why the international order has bound you up, Canada, and has bound up your domestic law, not to take action aimed at the destruction of those rights. And when you do, the Constitution says that those laws are of no force or effect because they are going against international order. So what's the hierarchy? Who's sitting on top? Is it our government, our legislators, our politicians, or is it the international order that is controlling domestic law, that has power over domestic law to put a stop to their operations of law, which steal our rights and limit our rights illegally?